For years, there was this number that everyone in the customs world just knew. It was a crucial assumption about financial penalties, a belief that a $30,000 cap was your safety net. But as it turns out, one landmark case blew that idea right out of the water, revealing it was a very, very expensive misconception, and it completely redefined financial risk for the entire industry.
So, what if I told you that a rule your whole industry has been following for years was wrong? Imagine a financial safety net that you thought you understood completely, only to have a court case suddenly reveal it was just an illusion. Well, that's exactly what happened here, and it sent absolute shockwaves through the brokerage community.
$30,000. This was the magic number. The whole industry believed that the maximum penalty a customs broker could get hit with for related violations was capped right here. It was a hard limit, a known risk. But, as we're about to find out, that comfortable understanding was about to get seriously challenged. All right, so how did this whole thing unravel? Well, to get it, we've got to look at a specific pattern of errors that led to this massive legal fight. And we're not talking about just one little slip-up. This is about what happens when those mistakes start to pile up one after another. The case that really brought this all to a head was a real heavyweight matchup. In one corner, you had the United States government, represented by U.S. Customs. And in the other corner, one of the biggest players in the game, UPS Customhouse Brokerage. You just know that when these two go head-to-head, the entire industry is going to be watching. Okay, so here's the play-by-play. Over just 5 months, the brokerage filed 45. Yeah, 45 separate entries with the exact same misclassification error. Now, the key thing here is this wasn't happening in a vacuum. Customs was sending warning letters, they even gave them training on how to do it correctly, but the errors just kept on coming. This pattern led Customs to say, hey, this is a failure of responsible supervision and control, which is a serious legal standard that basically means you have to actively manage your business to stay compliant. So, based on this pattern, Customs didn't just slap them with one penalty. Oh no, they assessed 5 separate penalties that added up to $75,000. Now, hold on a second. That's more than double the supposed $30,000 cap. This immediately set the stage for a huge legal showdown. How in the world was that possible? The entire fight really boiled down to how each side was reading the exact same sentence in the law. And that led to 2 completely different, fundamentally opposed views of what the statute actually meant. So here's the heart of the disagreement. The broker, UPS, said, look, the law's $30,000 cap is a total ceiling. All 45 of these mistakes are related, so they should all get bundled under one penalty that can't be more than $30K, period. But the government came back and said, not so fast. That cap applies per penalty notice. And since we issued 5 separate notices, we can assess up to $30,000 for each one. You can see how that math changes things fast. Now, the broker's side had some serious backup. The National Customs Brokers and Forwarders Association of America, the NCBFAA, jumped in to support them. They basically said, hey, we were at the table when this law was negotiated back in 1984. The whole point, the intent, was that the cap was a total limit for a violation or violations. But despite the industry's arguments, here comes the twist. The court's decision actually hinged on a really powerful legal principle. It wasn't just about what the law said, but about who gets to interpret the law when the words aren't crystal clear. And this is where something called the Deference doctrine comes into play. And that brings us to this term, Chevron deference. Now, I know, it sounds like some complicated legal jargon, but the idea is actually pretty simple. If Congress writes a law, and the language is a little vague or ambiguous, and they put a specific agency, like Customs, in charge of enforcing it, the courts will generally defer to how that agency interprets the rule, as long as their interpretation is a reasonable one. So the court followed this really clear, logical path. First, they looked at the law and said, yep, this is ambiguous. It could be read either way. Second, they confirmed, did Congress give Customs the authority to handle this? Yes, they did. And third, they asked, is Customs' interpretation of the law a reasonable one? They decided it was. So conclusion, the court defers to the agency. And the court also looked at the practical side of things. The judge pointed out that if they agreed with the broker, it would create a totally unworkable situation. It would mean Customs would have to find every single related violation in the country before issuing their one and only penalty notice. The court's exact word for that idea? Absurd. And with that, they sided with the government. So the gavel falls, the decision is made, and the entire industry is suddenly facing a brand new reality. What does this all mean for brokers and importers on a day-to-day basis? Let's break down the new bottom line. All right, here are the absolute must-know takeaways. First, and this is the big one,
That $30,000 cap is per penalty notice, not a total limit. A pattern of similar mistakes can lead to penalties that are way, way higher than that. Second, that phrase, responsible supervision and control, isn't just fluffy language. It's a critical standard you'll be judged by. And finally, this isn't just a broker problem. Importers, listen up. Your broker is your agent, so their mistakes can lead to separate penalties for you. You have a huge stake in making sure they're compliant. And all of this brings us to the final crucial question that this case forces every single one of us to ask. Knowing that penalties can stack up like this, knowing that the financial risk is so much higher than we once thought, you have to look at your own operations and be honest. Is your compliance program really truly built for this new reality? It's definitely a question worth thinking about.